Hello everyone, today I am here to explain the topic about the international treaties in research methodology and intellectual property rights. In contents, we discuss about the introduction, definition, codification, law of treaties, types of treaties, reservation, registration and publication, treaties and third states, and invalidity of treaties, termination of the treaties, at last conclusion. Let us know about the international treaties. The international conventions or the treaties that establish written rules that are binding on the states that have signed and ratified the conventions. The treaties are contractual in nature between and among the states and governed by international law. Nextly, the international custom that establishes unwritten rules that are binding on all the states, that is based on general practice. Their binding power is based on implied consent evidenced by a virtually uniform state practice over time, and secondly, a belief that such practice is a legal obligation. Thus, for the rules to become part of international customary law, states must follow them not out of convenience or habit, but because they believe they are legally obligated to do so. Nextly, the definition from Article 2p(1)(a) of the VCLT defines the treaty as an international agreement that concluded between the states in written form or governed by international law, whether the embodied in a single instrument or in two or more related instruments, and whatever its particular designation. This definition was formulated for the purposes of the Vienna Convention and does not define treaties at large. Other names commonly used for treaties that include convention, charter, protocol, memorandum, exchange of notes, declaration, covenant, agreement, pact, etc. The name given to a treaty may indicate its significance, however, it does not affect its legal character. The codification law of treaties. The law of treaties has been codified. The Vienna Convention on the Law of Treaties was signed at Vienna on 23rd May 1969 and entered into force on 27 January 1980 after being ratified by 35 states. The preamble to the 1969 Vienna Convention provides, however, that the rules of customary international law will continue to govern questions and not regulated by the provisions of the present convention. In the year 1969, Vienna Convention on the Law of Treaties applies only to the treaties that concluded by the states. An additional treaty dealing with treaties concluded between the states and international organizations was signed in the year 1986 in Vienna. It has not yet entered into force. Let us discuss about the types of treaties. Firstly, bilateral treaties. They concluded between two states or entities. It may have two or more parties. For instance, the bilateral treaties between the Switzerland and the European Union following the Swiss rejection of the European Economic Area. The agreement that 17 parties but are still bilateral as the parties are divided into two groups, the Swiss on the one part and the EU and its member states on the other part. Each of these treaties has the multilateral treaties, that a multilateral treaty is concluded among several countries. The agreement establishes the rights and obligations between each party and every other party. Each party owes the same obligations to all other parties except to the extent that they have stated reservations. Example: Convention relating to the status of refugees, the United Nations Convention on the Law of the Sea, the Geneva Conventions, the International Covenant on Civil and Political Rights, etc. Thirdly, the universal treaties. It is includes among almost all the countries, for example, United Nations Charter or the CITES Convention on International Trade in Endangered Species of Fauna and Flora, which is almost 160 parties. The contents of a treaty can be classified into three categories: law-making treaties that they establish general patterns of the behavior for the parties over a certain period of time in certain areas. Nextly, the contractual treaties regulate some specific cooperation between the states, such as transboundary movement of specific hazardous waste. Next is reservation. A state may, while signing, ratifying, accepting, approving, or acceding to a treaty that leads to formulate a reservation. Reservation means a unilateral statement, however phrased or named by the state, by which it intends to exclude or to modify the legal effect of a certain provisions of a treaty in their application to the state. Formulating reservations is permitted unless the reservation is prohibited by the treaty or it is incompatible with the object and purpose of the treaty. Other states may accept or object to the reservations from the Article 309 of the 1982 Convention on the Law of the Sea provides that no reservations or exceptions be made to this convention unless expressly permitted by the articles of the convention. Registration and publication. Treaties that may be concluded by the member states of the United Nations have to be registered with the Secretariat of the United Nations. From the Article 102 of the Charter of the United Nations provided that every treaty and every international agreement entered into by any member of the United Nations after the present charter comes into force shall as soon as possible to be registered with the Secretariat and published by it. All treaties registered or published in the United Nations Treaty Series, that is http://www.un.org, and translated into world languages if necessary. There are more than 30,000 treaties registered and published since 1980. Nextly, treaties and third states. In principle, a treaty does not create either obligations or rights for a state which is not a party to that party from the Article 34. In exceptional circumstances, a treaty may provide for obligation for third states if they expressly accept that obligation in writing from the Article 35. A treaty may also provide for rights for the third state, a group of states, or to all the states if the third states assent thereto. Their assent may be presumed from the Article 36. An example of a treaty providing for all rights for all the states in 1936 Montreux Convention providing for the freedom of navigation on the Turkish Straits. Invalidity of treaties. The validity of a treaty or the consent to be bound by a treaty may be impeached. Invalidity eradicates legal effects of the treaty. The reasons which may lead to invalidity of the treaties that may include a manifest non-compliance with municipal law of fundamental importance regarding competence to conclude the treaties from Article 46, omission of restrictions of authority of a state representative if the restriction was notified to the other negotiating states from Article 47. Thirdly, the error, if related to the fact or situation which was assumed by a state to exist at the time when the treaty was concluded and formed an essential basis of its to be bound by the treaty from the Article 40. Determination of treaties. Determination of a treaty may take place in conformity with its provisions or by the consent of all the parties to that treaty. Also, a treaty terminates if all the parties to it include a new treaty relating to the same subject that matters. A treaty may also be terminated as a consequence of its material breach by one of its parties from the Article 60 because of a supervening the impossibility of a performance resulting from the permanent disappearance or destruction of an object indispensable for the execution of the treaty from the Article 62. At last is conclusion. The process of concluding a treaty may vary depending on subject matter and the number of parties that involved. Every state possesses capacity to conclude the treaties. In the process of concluding international treaties, states act through their representatives. State representatives have to produce full powers. A full powers means a document emanating from the competent authority of a state designating a person or persons to represent the state for negotiating, adopting, or authenticating the text of the treaty, for expressing the consent of the state to be bound by a treaty, or for accomplishing any other act with respect to a treaty. Heads of the state, heads of government, and the ministers for the foreign affairs, by virtue of their functions, can perform all acts relating to the conclusion of a treaty without having to produce full power as from Article 7. Thank you, everyone.